Good evening to all of you. Welcome to Legal Matters by Sai Baba Sankara. We are going to discuss what type of property can be attached under Order 21 or Section 60 of the Code of Civil Procedure. Section 60, Subclass 1 clearly says that the pensions, the gratuity, the medals amount and the personal amounts like LIC cannot be attached at any cost because they are the personal payments to the so-called person. So they cannot be attached. So an incident has come to light. Of course, I searched for the citation, but the case details are not available, but the information is 100% available. So better to discuss. Justice P. Madhavi Devi of Telangana High Court, while disposing the writ petition number 1034 by 2021 on 21st November 2022. The case law is not available for me. If anybody can cite the case law, I will be happy. Pension and the gratuity amounts of the retired employees can be attached for the satisfaction of any decree, maybe under Order 21 or maybe under Section 60 of the Code of Civil Procedure. This is reiterated. Actually, while dealing with the section, I have clearly told you that such pensions or gratuity amount, they are not at all liable for attachment. Why? Because what is the purpose of pension? All of you know. An employee having worked for 35 years and having not saved anything, at least should have get some monthly income. ఒక గతంలో అంటే ఇప్పుడు పరిస్థితి కొంచెం మారింది అనుకోండి. గతంలో ఒక ఉద్యోగస్తులు సేవింగ్ మెకానిజం ఉండేది కాదు, సేవింగ్ తెలిసేది కాదు. ఆ కాలంలో 30 సంవత్సరాలు గొడ్డు చాకిరీ చేసిన తర్వాత నెక్స్ట్ మంత్ నుంచి రిటైర్ అయిన తర్వాత నుంచి ఏమీ రాకపోతే అతను ఎలా బాధపడతాడు అనే ఉద్దేశంతో, సదుద్దేశంతో ప్రభుత్వం వారు ఆలోచించి పెన్షన్ స్కీమ్ పెట్టారు. ఇట్స్ పర్సనల్, ఎంత వచ్చిందో అతనికి ఉపయోగపడాలి. సెకండ్, గ్రాట్యుటీ, అవుట్ ఆఫ్ గ్రాటిట్యూడ్. మీరు 30 సంవత్సరాలు ఈ యొక్క శాఖకి సేవ చేసినందుకు గుర్తింపుగా మీకు 10 లక్షలు, నాకైతే 7 లక్షలు ఇచ్చారు రిటైర్మెంట్. 10 లక్షలు, 20 లక్షలు, ఇప్పుడు 20 లక్షలు అన్నారు, ఇచ్చారు. ఆ డబ్బుని ఇట్ ఈస్ నాట్ liable ఫర్ అటాచ్మెంట్. సో దిస్ ఈస్ the very purpose, this is the behind story of the pensions and gratuities. Therefore, they are not at all liable for attachment. Right, coming to the facts of the case, the petitioner, she is a lady. She worked as a record assistant in some office, I don't know the office name, and she retired on 31/7/2020, very recent case. So, she retired on 31/7/2020. So, and actually, before granting the pension, you may be knowing, they will check up whether any enquiries or whether he is actually we have to give a certificate also that he is not indebted to any of the departments. Like on the house loan advances ఉంటాయి, లేకపోతే హౌస్ అకామిడేషన్ దాని డబ్బులు ఉంటాయి. ఇవన్నీ క్లియరెన్స్ ఇచ్చిన తర్వాత his pension will be released. Right. So, as a routine process, after 1 or 2 months of retirement, she filed an application for the benefits of the retirement as well as gratuity and other things, surrender, then general insurance policy and also pension, all these things. But the pension was not released even after 5 months. We were shocked. Why this pension has not come to me? When she approached the concerned officer, then it is clearly learned that 2 chit fund organizations, Marga and another chit fund, Marga and Shreya chit funds, they have filed recovery suits against the so-called pensioner. 2 EPs recovery suits were filed against the pensioner. Why? Because she stood as the surety. Therefore, I have already told you, Section 145 of the CPC, liability of the surety. So, దీని ప్రకారము ఎవరైతే షూరిటీగా ఉన్నారో, ఎవరైతే డబ్బు డిఫెండెంట్కి లేకపోతే జేడీఆర్కి ఎంత బాధ్యత ఉంటుందో షూరిటీకి కూడా అంతే బాధ్యత ఉంటుంది. దట్స్ వై మార్గదర్శి కేసు ఎప్పుడూ ఉదాహరణ చెప్తుంటాను. Marga, that is Shreya Chit Funds. They have filed cases for the recovery. Since the court has given order that the benefits and that the salary can be attached. Make this the Garnishee order. You all know. So Garnishee means judgments, debtors, debtor. మనం ఒకటికి అప్పివ్వాలంటే వాడు ఎవరికి ఇచ్చున్నాడో వాడిని. సో ఇక్కడ మున్సిపాలిటీ ఈ డిపార్ట్మెంట్ తెలియదు, ఆ డిపార్ట్మెంట్ వాళ్ళు ఉన్నారు కాబట్టి ద కోర్ట్ హ్యాస్ గివెన్ గార్నిషీ ఆర్డర్ directing that the emoluments or the salaries of this particular petitioner can be paid to the chit funds department. You all know section 60, 61 or order 21 lo kuda cheppam. 12 months continuous period, maximum 24 months, then there should be 1 year gap. So take home salary 1/3, all these things you know. I need not reiterate once again. So ee prakaram vaste asalu ikkada paristhiti enti, these orders were given. Please remember, maybe in the year, I think they have given the numbers also. 118, yeah. One is 306 by 2019 and another is EP 215 by 2020. So before retirement, one Garnishee order was given. After retirement, another was given. That means the court did not know that she is about to retire. Right? Anyway, since an order has come to the court, immediately the department stopped payment of the pension, stating that the court has given directions that the amounts have to be recovered in equal installments or things like that. We are not going to pay the salary. Then she filed a petition before the Honorable High Court of Telangana. Yes, yeah. The arguments on behalf of the petitioner are that section 60 CPC clearly says that the pension and gratuity amount, they cannot be attached. Of course, the government pleader, he already stated that yes, Your Honor, it's correct, but some other amounts are there. And HBA, house building advance or something is like that. So from that, about 5 lakhs has to be sent back to or paid to the so-called chit funds, and the other amount may be released. Yes, the issue is settled. Here, normally the department, in this case, what we have to discuss, the department is unaware of the provisions of law. శాఖలు ప్రభుత్వ శాఖలు ఇప్పుడు తెలియాలి ఎక్కడ ఉంది, ఆ శాఖకి కోర్టు ఆర్డర్ ఇచ్చింది ఆపేశారు. కానీ ప్లీజ్ రిమెంబర్, ఇఫ్ యూ ఇక్కడ రిట్ పిటిషన్ వచ్చింది కాబట్టి తెలిసింది. ప్లీజ్ రిమెంబర్, అకార్డింగ్ టు సెక్షన్ 60, ప్లీజ్ రిమెంబర్ the so-called gratuity and pension amount, they cannot be attached. Another sections kuda teluskondi. Section 11 of the Pension Act 1871 and also section 13 of the Payment of Gratuity Act 1972, they also put a bar. Not only section 60 CPC, so section 11 of the Pensions Act 1871 and also section 13 of the Payment of Gratuity Act 1972. Besides that, please remember, when KCR has come into power, he has given a circular. I know that Telangana government, in its circular number 15595, 15,595, dated 24/12/2016, clearly assured that the retirement benefits should be paid to the retirement employee on the date of retirement. So she retired on 31/7/2020, and of course because of the EPs 215 by 2020 and also 306 by 2019, the amount was held up. Now the court has clearly stated that the Garnishee order by the court is 100% relevant, but the point is, if any amount other than the pension, if any amount other than the gratuity is there, yes, they are recoverable. They are adjusted at 5 lakhs and the rest of about 25 lakhs also was paid to this petitioner. So please remember, in this connection, the Honorable High Court of Telangana, they placed reliance on a beautiful case, Radheshyam Gupta versus Punjab National Bank, so 2009. So based in reliance on same, since the facts of the case are similar to this, so they have already ordered these people to release the payment and gratuity within 2 months from the concerned department. Very good case law. I am sorry to say that I could not find the citation. Whenever I find it, I will write it in the remarks column or the details column. So for the present, I am concluding. Thank you very much.